There's no enumerated power within Article 2, as Judge Katsas noted, for Trump's conduct. Civil immunity is totally a judge-created doctrine using the same sort of free-flowing structural reasoning that I think puts a lot of the conservative justices' teeth on edge. And so, I could imagine a kind of coalition among 5 or more of the justices, especially if they do a very narrow ruling.
I'm Benjamin Wittes, and this is the Lawfare podcast, December 9th, 2022. The D.C. Circuit Court of Appeals on Wednesday heard oral arguments in the case of Blassingame versus Trump, an appeal from a civil lawsuit against the former president over January 6th. The question before the appeals court: does a president have immunity from lawsuit even when he's accused of stirring up a mob against a coordinate branch of government engaged in a function constitutionally entrusted to it? The judges seemed skeptical of the former president's argument, which was a bit of a surprise given the composition of the panel. Joining me in the virtual jungle studio to chew it all over is Alan Rozenshtein, Lawfare senior editor and professor at the University of Minnesota Law School, who followed the oral arguments and live tweeted them. We talked about the case that gave rise to the arguments. We talked about how it played out at the lower court, and we talked about what the Supreme Court might do when it confronts this question down the road. It's the Lawfare podcast, December 9th. Alan Rozenshtein says the slope isn't that slippery. Alan, let's start not in the D.C. Circuit, which heard arguments today, but in the district court. What is this case about, and what happened at the lower court that the D.C. Circuit was talking about today?
Sure. So this case stems from a series of lawsuits that a number of individuals have filed against not just President Trump, but also close associates like Rudy Giuliani, stemming from the actions of those people on January 6th, which, as Lawfare listeners all know, involved some inflammatory speeches by the president, which ultimately resulted, or at least was followed by, an armed attack on the Capitol. In the wake of that, a number of lawmakers, including Democrat Benny Thompson, who was the lead Democratic plaintiff, as well as several Capitol police officers, in particular James Blassingame, who is the lead plaintiff in the kind of titled case in the D.C. Circuit, they sued Donald Trump under a variety of basically tort theories. And the district court, Judge Mehta in the District of Columbia, actually allowed those theories to go through. I'm going to focus here on those relating to Donald Trump because they raise the most complicated legal issues. In the lower court, Judge Mehta held two really notable things. The first thing he held was that the First Amendment did not, in fact, protect Trump's January 6th speech because that speech was arguably criminal incitement. The second thing that Judge Mehta held was that Donald Trump should not get the absolute civil immunity that, under the Supreme Court case Nixon versus Fitzgerald, presidents get when they're acting within their official capacity, because the speech on January 6th was really Trump acting as a political candidate rather than a president. When the judge issued that order or that decision, Trump appealed, but he appealed specifically, and I think this was for procedural reasons, on the immunity question. And so what the D.C. Circuit heard this morning, and we're recording this on the afternoon of Wednesday, December 7th, what the D.C. Circuit heard was argument on this immunity question in particular.
Okay, so just for those who are not civil litigation specialists, this is therefore a appeal of a denied motion to dismiss on grounds that President Trump, being the president of the United States at the time of the alleged conduct, is immune from civil liability for basically anything that he does while president that could conceivably be a part of his role as president. Walk us through where that idea comes from.
So that idea is not in the Constitution. It's not in the text of Article 2 or Article 3. It's a judicial kind of constitutional common law that really gets its clearest expression in the Supreme Court case Nixon versus Fitzgerald, which involves the former president Richard Nixon. And in that case, Nixon fired a particular individual in the executive branch, and that person raised a basically wrongful termination lawsuit. And what the Supreme Court held in that case was that Nixon was absolutely immune civilly for the firing, even if the firing was unlawful. This is important. Even if the firing was unlawful, because firing and hiring and these sorts of core, bureaucratic management activities are centrally within the powers of the presidency. And so for functional considerations, really to prevent the courts from micromanaging the president and to prevent the president from having to look over his shoulder and contemplate future civil liability every time they took some action, this extreme absolute civil immunity was appropriate. And so Trump, throughout the litigation, both at the district court and then today at the DC Circuit, really was just hammering home that this is just a classic Nixon versus Fitzgerald case, and that the civil immunity is required under clear Supreme Court precedent.
All right. So before we get to today's argument, let's sketch out the parameters insofar as they're known of Fitzgerald immunity. On the one hand, the language of Fitzgerald is quite broad. It says anything, I don't have it in front of me, but it basically says if the conduct is within the sort of outer reaches of the presidency's official duties, he's immune. On the other hand, you have Jones v. Clinton, which involves an alleged sexual harassment or encounter before Bill Clinton becomes president, where the Supreme Court says, hang on, that's not within the outer reaches of his duties as president because he wasn't president yet. Is that the scope of is that everything we know about the scope and reach of Fitzgerald? Or it doesn't reach your conduct before you were president or presumably after you were president. And there's some theoretical thing you could do that would be outside of the boundaries of your duty as president while you were in office, but we don't know what it is, that would exceed Fitzgerald's protection. Is that a fair summary of the state of play?
Yeah, that's basically right. The language in Fitzgerald is, quote, outer perimeter. And obviously, if you read that language and you read the context, the Supreme Court is very much trying to put the thumb on the scale in favor of civil immunity for actions the president took while in office. But of course, outer perimeter, it's one of these really vague and abstract terms that unfortunately we don't actually know the content of until the Supreme Court later comes and interprets it. And the Supreme Court really hasn't had an opportunity to squarely explain to lower courts or to the rest of us, as it were, what the outer perimeter really amounts to. Clinton v. Jones is an interesting case, but again, it's not that useful because because again, as you pointed out, the conduct occurred before Clinton was president. So it really doesn't get at the functional justification for Nixon Fitzgerald, which again is this concern about chilling the activities of the president. It is pretty clear that this immunity is not absolute because it doesn't go beyond the outer perimeter. And so one can imagine a number of hypotheticals where the president, invites his close friend over to the White House for a drink and they get into a fight and the president punches him in the face.
Commander-in-chief power.
yeah, that's it. In that case, I think it's pretty clear that there would be a cause of action. And so you can come up with these sort of edge case scenarios. But outer perimeter is very broad language. And unfortunately, until the Supreme Court decides to revisit the issue and tell us what it means, we are stuck kind of grasping at straws a little bit.
All right. So one of the features of the way our appellate system works is that the DC Circuit has to grasp at straws and can't simply ask the Supreme Court, hey, could you give us a little guidance here about what your precedent means? They have to guess, and then the Supreme Court gets to reverse them. But one thing they do have to do so that they have a stable factual record is that they have to assume true all of the allegations in the complaint, because this is a motion to dismiss. So what are the facts that they are working with here that they have to presume true about Donald Trump as they ask whether he is immune for these facts falling within the outer perimeter of the president's official duties?
Yeah, so this is where it gets a little complicated, because the complaint here was filed relatively soon after January 6th. And that means it was filed before a lot of the most serious and damning evidence that the January 6th committee has uncovered about President Trump's state of mind, his now infamous order to remove the magnetometers, his attempt to go to the Capitol, his clear disregard of the potential for violence, the fact that he was warned a bunch of times. Really, the main evidence is the text of his remarks, the quote unquote stop the steal rally, along with sort of the general context that we knew of at the time, which was that Trump had for months been baselessly attacking the integrity of the election and creating a kind of hothouse powder keg environment. This is why I think at least, and I know a lot of some other people were quite surprised actually when the district court ruled in favor of the plaintiffs, because I think I assumed that the district court would say this official immunity question is actually quite hard, but the First Amendment question is relatively easy, at least on the facts as we know them. Now, the district court ultimately held that the First Amendment did not protect those remarks. And since then, we have discovered a bunch of additional facts that I think support that decision, but for different reasons. So this is an odd kind of situation where the allegations against Trump have actually been increasingly substantiated since the allegations were made, but not because of anything the plaintiffs have put forward, because of what has come out as the January 6th committee has done its work. And so that's kind of, I think, the background context.
But just as we have to assume the allegations true, we also can't amend the complaint for the plaintiffs. We have to use the allegations that they alleged, not the allegations that Liz Cheney alleged that they will presumably incorporate in the course of some kind of amended complaint later on, right?
Yeah. So the short version then of the facts is that Donald Trump stood up and gave a speech in which he lied about the election, told his supporters to fight, told them to go to the Capitol, and that in the context of that speech and in the context of what had been building over the last several months, it was foreseeable in some sense, in a sense that is relevant to negligence liability, that the violence that transpired would have transpired. That is the factual assumption here.
All of which brings us to the question of whether a president is immune from civil liability for such facts. Again, assuming them all true and ignoring everything else we know about what Trump did. So how did the argument go today?
So the argument was interesting. I think the argument went relatively poorly for Donald Trump. So let me say a few things about that. So first, the panel was 3 judges: Chief Judge Srinivasan, Judge Katsas, and Senior Judge Rogers. I think just looking at the panel, there was some good things and bad things for Trump in there, right? You have 2 Democratic appointed judges in Srinivasan and Rogers. Katsas was, of course, appointed by Trump himself. On the other hand, both Srinivasan and Rogers, before they were judges, had extensive DOJ experience, and so could be expected to be fairly, I think, sensitive to the equities of the executive branch and not super eager to blow a big hole in immunity. But what I found to be quite interesting was actually just how skeptical Judge Katsas was of Trump's theory from the very beginning. And he really didn't let up. To Trump's argument this whole time and articulated, I think, fairly well by his lawyer, though I think his lawyer had the losing side of the argument ultimately, was that whenever the president speaks on matters of public concern, he gets civil immunity from that. Just
because speaking is part of the president's duties, speaking on matters of public concern.
It's certainly a part of the president's functions. And there was some discussion about duties and versus functions and the specific language in Nixon versus Fitzgerald. But I think there's a general agreement that the bully pulpit is certainly in the last 100 years, at least, has become a core part of what presidents do. And so if you're using the bully pulpit, and in particular, if you're using the bully pulpit for something that has to do with public concern, and it's pretty clear that elections have something to do with public concern, that's it. That is enough to trigger Nixon versus Fitzgerald immunity. And the reason is not because everything the president does is okay in that context. And in fact, the president's lawyer went out of his way to emphasize just how terrible the conduct might be and how appropriate impeachment and even criminal prosecution might be, but rather because to avoid the slippery slope of creating an opening for judges and litigants to flood the president with, this sort of intrusive oversight, you needed to draw a really hard, bright line. And I think the judges were just not having that, frankly.
All right, so let's talk about what the judge's objection to that was. Judging from your tweet thread about it, they seem to have slightly different anxieties. So walk us through the three judges on the panel's reaction to this argument.
Yeah, so I think that the anxieties of, in particular, Katsas and Rogers, and I wouldn't be surprised if this is shared by Judge Srinivasan as well, is that the slippery slope that Trump's attorney was alleging is not actually that slippery, because the conduct that is alleged here is not, or let me put it this way, that the conduct alleged here is so out of the ordinary, it is so extreme that it is, in Judge Katsas's words, a colorable incitement to violence, that you could create kind of a fairly small exception to the general immunity without the parade of horribles that Trump presents, because it's just not that frequent that the president gets up and says something that rises anywhere near the level of incitement to violence. And I think that was the thing that, in particular, Katsas and Rogers kept coming back to. So that was kind of, I think, Katsas and Rogers' main concern. I think Srinivasan shared that concern, though he also had concerns about whether or not the standard that Trump's attorney articulated, whether that went too far. Because you can imagine situations in which the president gets up on the bully pulpit and starts talking about how, you should go and you should buy my products because I'll make a lot more money. And by the way, I'll be even better president for you. And under the very broad theory of what Trump was putting forward in terms of civil immunity, that would also presumably make the president immune. And that seemed to go beyond what Nixon versus Fitzgerald was about.
All right. So the other side's argument, the plaintiff's arguments, presumably here contend that this has to be somehow outside of Fitzgerald. There are a number of ways you can get to that. One of them is what you just said, a sort of exception for the narrow case where the president is inciting violence. But you could also say, as if memory serves, the lower court said, hey, come on, he's here at a campaign rally, although it was after the election, but it's not his official function. He's there in his capacity as a candidate who lost. What is the plaintiff argument that we're outside of Fitzgerald land here, and how did the court receive that?
Yeah, so there's the district court's argument, which is really about this is Trump as a candidate rather than Trump as president. And that is something that the plaintiffs argued in their briefs. But the main discussion between the plaintiffs and the court was about a different theory of why Trump should not get immunity. And the theory there is that in this particular case, what Trump was doing interfered with the internal functions of a coordinate branch in a domain where the president has no role. So the petitioner was also making a kind of bright line constitutional argument that, look, the Constitution makes very clear that the transfer of power is something that only Congress is in charge of, and that because of that, if the president is trying to do anything that interferes with that, the Constitution explicitly takes that out of the president's power, and therefore the president can't claim immunity there. And I think the court was more receptive to that, but they pointed out that that itself has its own line drawing difficulties. So, for example, I think this was something that Chief Judge Srinivasan got into with the petitioner. That, well, what if you have a situation in which it's very difficult to tell where the president's duties end and Congress's duties begin? What if, for example, we're at a press conference and someone asks the president about what he thinks about the Electoral College vote, and the president says some words about how he thinks that, it's not going well or something, and that leads to violence. Does he not get immunity because he was involving himself in something that Congress is in charge of? Or does he get immunity because, after all, talking to reporters is something that he generally does? So, what I think, kind of zooming out, was interesting about this case was that usually plaintiffs come in and they really want to focus on the facts of their case, right? They want to say, look, you should give me relief because my clients, the facts are really on my client's side. And don't worry about the second and third order consequences of ruling for my client. Let's just focus on my client. And judges say, no. Your client's important, but we're making law and we have to make law generally. Here, you almost had this reversed a little bit where both sides, Trump, the plaintiffs and Trump, are coming in saying, hey, we each have this broad theory of presidential immunity, and you should adopt our theory. And under our theory, our plaintiff, our client wins. And the courts want to say, actually, none of your theories are that good. Can we just focus very narrowly on the fact pattern in front of us and just decide this on the narrowest possible grounds? This conduct by Trump is so bad, it's so beyond what any normal, within parameters, president would do, that we could kind of just rule against Trump as a one-off and not have to answer any complicated questions about presidential immunity, because this is such a weird case that ruling against Trump will not have really any second and third order effects on future presidents. And I thought that was an interesting inversion of what I think you often see in these kinds of cases.
So when I listen to you describe this, it seems to me there is a potential hybrid approach that the court could take, which is to say, Fitzgerald clearly contemplates that there is some bound beyond which presidential conduct can give rise to civil immunity. It states that such a line exists, but doesn't get anywhere near defining it. We also don't have to define that line. All we have to say is that where you're dealing with a campaign-like rally in which, on an issue in which there's a affirmative delegation of power to a coordinate branch of government, where the president colorably incites violence against a coordinate branch of government, wherever that line may be, we're confident we're well over it. And I guess the question is, do you think they're going to try to define the line, or do you think they're going to focus on the outrageousness of the action here and say, actually, there's some case that may force you to articulate the line. Here, we're just going to say if the U.S.-Canadian border, we don't have to define where it is because you're in New Mexico.
Yeah, I think that's a great way of putting it, and I say that with nothing but love for our listeners in New Mexico. You're a wonderful part of our union, and we're not trying to compare you to Trump's incitement to riot.
No, just merely saying that you're not anywhere near Canada.
Definitely not anywhere Canada. No, I think that's exactly right, and I think this is actually a very it's kind of very old school kind of judicial minimalism that I think has fallen out of favor with all sides of the political spectrum. But I think it's particularly appropriate when it comes to separation of powers disputes. And the reason is that drawing lines and drawing crisp conceptual boundaries is an important thing that courts do and lawyers do. But it's easier in some domains than others. And it is very hard in separation of powers because under the original constitutional design, these powers themselves are not particularly well defined. We talk about the legislative power and the judicial power and the executive power, but the moment you actually try to draw them out, it's very fuzzy. And there's a real surprising amount of overlap. And it's not clear where the legislative power ends and the executive power begins and so forth. Not only that, but you have an additional feature of our constitutional system, which is that even if we did have crisply defined legislative, executive, and judicial powers, those actually don't map crisply to the three branches of government. The Constitution does not, although there are these vesting clauses, the Constitution does not actually make Congress entirely and exclusively in charge of the legislative power. We know that, of course, because, for example, the president signs laws and can veto them. Similarly, the president doesn't 100% have the executive power because, for example, the Senate has to confirm his appointees. And all throughout the Constitution, you have this division of power among the different branches. Now, there are good reasons for that, but one of the results is that it's very, very, very difficult to say very cleanly what exactly is the circle, right, around the president's powers. And in particular, is that totally separate from Congress's powers? And so I think that if the judges can avoid doing that, they will, especially given, that again, to use your analogy, we're much more in New Mexico than we are in, my home state of Minnesota, right? Where you actually might at some point need to define the US-Canadian border.
All right. So let's talk about how this plays at the Supreme Court, because as you alluded to earlier, the DC Circuit is really a way station here, assuming the Supreme Court wants to resolve this issue. Now, Judge Katsas, who is a luminary of the conservative bar, served in the Donald Trump White House counsel's office. So I would think that if these judges are roughly on the same page, a opinion by Judge Katsas on this subject, unanimous for the three of them, would be an extremely powerful message to the Supreme Court. Do you agree?
I do agree. I mean, I was really, really surprised at just how unconvinced Judge Katsas seemed by Trump's argument and how quickly, he was the first one in the argument to raise the sort of, let's be real here. What we're talking about is a plausible case of incitement to violence. Let's focus on this. And I think if that's what the DC Circuit ultimately rules, look, the Supreme Court doesn't need cover from the DC Circuit, but I do think there is a constituency for that on the Supreme Court, especially if they can, reaffirm Nixon Fitzgerald generally with a very small carve out. I think this is especially true because, it's not like, frankly, the text or I think original understanding of the Constitution is particularly on Donald Trump's side here, right? There's no enumerated power within Article 2, as Judge Katsas noted, for Trump's conduct. Civil immunity is totally a judge-created doctrine using the same sort of free-flowing structural reasoning that I think puts a lot of the conservative justices' teeth on edge. And so, I could imagine a kind of coalition among 5 or more of the justices, especially if they do a very narrow ruling.
All right. So when you look to count votes at the Supreme Court, it seems to me there's almost no basis on which to do that. The only justice, I think, who was there at the time of Clinton v. Jones was Clarence Thomas, and that was a unanimous opinion anyway, and it doesn't really address this question. There are no justices left from Fitzgerald. And so I think, I'm not sure, but I think the most that you can say is that judicial conservatives tend to be more solicitous of executive power claims than more liberal justices. That said, Judge Katsas's reaction here suggests that too may have limiting principles. Do you see any basis on which to assess where the Supreme Court is likely to be on this subject?
Not really. I mean, I think you can point to specific justices and speculate on some of the factors that are going into their minds. I mean, obviously, you look at someone like Justice Kagan, who on the one hand is part of the liberals on the court, and I think it's very unsympathetic to the conduct at issue. At the same time, was the Solicitor General, has written in favor of presidential administration. I think is very sensitive to these equities, and so not someone who I would expect to want to blow a giant hole in Nixon versus Fitzgerald. When you get to the conservative justices, again, it's tricky, right? I mean, you have Justice Thomas, who on the one hand takes the idea of unitary executive power very seriously, but on the other hand, I'm not sure there is much of a constitutional basis for this sort of civil immunity. And so you can imagine him saying, I'm just going to follow the Constitution and not provide this. I think also, and here, I think you get into a little bit of Supreme Court psychodrama, but, for speculating, let's speculate. You have three justices appointed by Donald Trump. Again, I obviously don't know. I don't think any of these justices are particular MAGA partisans in the sense that, they come from much more of a establishment conservative legal movement than from, judicial MAGA land to the extent that it exists. And I think that consciously, or I suspect more subconsciously, they have no problem ruling against Donald Trump. And in fact, it helps them in the sense of burgeoning their credibility. I think we saw a little bit of that, frankly, in how poorly Trump did in his judicial challenges in the 2020 election. I mean, mostly because they were totally meritless. But I think in part because Gorsuch and Kavanaugh and Barrett had no particular interest in sticking their necks out for Trump.
And just to be clear, that's because they're ungrateful losers, right?
Yeah, definitely. It's exactly right. In all caps, no doubt as well. And so I think you could see a situation in which you have a very narrow decision, which would be obviously bad for Trump. It would also be in some sense a bit unsatisfying because this question of the proper scope of civil immunity is really important. I think it's going to come up more and more. And Nixon versus Fitzgerald is just not a very satisfying decision. But this may not be the vehicle, unfortunately, for kind of a broad rearticulation of when civil immunity is or is not appropriate.
So how much do you think this case matters? It obviously matters to Donald Trump in the sense that you could really imagine, in the absence of Fitzgerald immunity, his personal liability for January 6th kind of spinning out of control. But most presidents don't gin up mobs to organize coups. And, so if you imagine a narrowly crafted opinion that basically throws Trump to the plaintiff lawyer wolves, I'm not sure that would have a lot of implications for the presidency more generally. Do you think there is a real risk here of articulating a principle that will sort of open precisely the floodgates that Fitzgerald was designed to slam shut? Or is there a way to do it that, really treats Trump like the black swan event that he is?
Yeah. So, I mean, I think there are two questions in that. I think there's one question about what does this mean for Trump? And then what does this mean, or what would a verdict against immunity mean for Trump versus what would a verdict against immunity mean for the presidency? I mean, I think for Trump, it would be bad for a number of reasons. I think it could be financially quite costly for him. It could be very embarrassing. Also, if this case goes forward, we're getting into discovery, we're getting into depositions. I mean, we're getting into some real legal process in addition to everything that the January 6th committee has done. And so this is just going to keep in the news Trump on January 6th, for the next year or 18 months as he's running for president. And, I think what we've seen politically speaking is that actually Americans don't love what Trump did on January 6th. It is not good for him. And so I think you could have some real repercussions, not just financial, but political in that regard. With respect to the presidency, I think this is the ultimate question, right? Can you draw an opinion that is really narrowly crafted? And I think you can. And I think you just let Judge Katsas do it, frankly, because I think he has a very clear understanding of how to do that. It is hard to think of anything that goes even remotely close to what Trump did on January 6th, both in terms of the lead up to it and his conduct on that date, his refusal to then intervene. I mean, they're just such sui generis facts. And so, you could have an opinion that deprives him of immunity. And I just don't think that it would create, I don't think the slope is that slippery, to put it another way, because of these facts. I think this is one of these rare cases where bad facts can make good law, actually, because they lend itself to this sort of cabining, right? The rule is,
it's hard to trip over the border and find yourself in Canada from Mexico.
Exactly, right? If you want to avoid civil liability, don't whip up angry mob up to attack a coordinated branch of government, right? And of course, part of what lawyers are paid for is to say, oh, but if that, then this and this and this and the parade of horribles. But honestly, at some point, it's not that hard to draw a marker and say, no, we just meant this. Like, this really is different from the million other things the president does.
We are going to leave it there. Alan Rozenshtein, the slope is not that slippery, but it's good to hear your voice. We will talk again on this when the opinion comes down. The Lawfare podcast is produced in cooperation with the Brookings Institution, and today it is produced in cooperation with the University of Minnesota School of Law. Our audio engineer this episode is the impresario of Goat Rodeo himself, Ian Enright. That does not change the fact that you need to become a material supporter of Lawfare. In fact, it reinforces the fact that you need to become a material supporter of Lawfare, because if you don't, Ian may go hungry, his children will go hungry, and all of Goat Rodeo's employees may go unpaid. Become a material supporter at patreon.com/lawfare. That's patreon.com/lawfare. The Lawfare podcast is edited by the great Jen Patja Howell. Our music is performed by the equally great Sophia Gann. And as always, thanks for listening.